just hit OK on that button. Do that every time it comes up.
If you don't mind. Call this morning's docket. Please say present or here. Raise your hand so I can acknowledge you for the docket. Cody Wheeler. Is Cody Wheeler here? Megan Bueno. Landon Watson. Haley Gandy. Travis Skinner. Shelton Vasquez. Shelton Vasquez. Mr. Sanders is here. I don't know if he could be speaking with Mr. Vasquez. I'm not sure. So we'll double check that. Amethyst Wesley. Amethyst Wesley. Deshaun Whitaker. Danny Dittman. Didn't Mr. Dittman fail to appear at our last setting as well?
So I think I'm not certain last one.
A couple. Okay. Logan Murrow. And Nathaniel Whiteley. All right. What do we anticipate to be contested or evidentiary hearings today?
We have all my clients are hanging up here. I think you have and
So no contested hearings this morning?
No.
Okay. I just had a note that maybe Bueno and maybe Whiteley were going to be contested. No?
Motion to discuss on this one.
Okay.
We're in agreement. Steve.
Would you do me a favor? I'm gonna deal with your in just a second, but oh, never mind, there he is. Mr. Sanders, can I see you real quick? Mr. Skinner, can you come forward as well? Mr. Skinner, and I'm not calling the case just yet. This is Investigator Bill Crawford with the Van Zandt County Criminal District Attorney's Office, and he has a search warrant to get a specimen of your DNA this morning. So he's going to take you across the hall. It's going to be a buccal swab. Is that right? So he's just going to take some DNA of the interior of your mouth. So it'd be very non-invasive, but you need to go with him so he can execute that warrant and then return to the courtroom, and then I'll call your case.
Sure.
Okay. And if you have any questions about that, you can speak with Mr. Sanders. Mr. Sanders, any of your clients, I've called a few and I didn't know if perhaps they were in the hallway speaking with you. Do you have Shelton Vasquez with you? Okay. All right. And what about Amethyst Wesley?
No.
Mr. Whitaker's here. I've got him, but so Amethyst I didn't have. And so, but you do have Vasquez in the hallway.
Yes.
Okay. All right.
And
That's
I'll give Ms. Wesley a call because I was trying to switch from Tuesday to Thursday, but I thought she knew. I even sent her a text. That's not her number, but I'll call to you straight. So you
Okay.
can find out.
okay. And as soon as you're ready on any of yours, let me know and we can get them going.
Please, maybe a third.
Who are you anticipating pleading? Haley Gandy is one.
Yes, Gandy and Mr. Whitaker.
Mr. Whitaker. Okay.
And I think with Mr. Vasquez, I think we should have have that worked out, revocation.
Okay. All right. I'll let you do what you do. And Derek Bolden is not here. Is that correct? Karen. Come on up, gentlemen, right up here. All right, so Mr. Wheeler, you're here for a sanctions status hearing, and we're gonna have you drug tested this morning, okay? So just have a seat right over here, and Mr. Crawford will be here from the probation department in just a minute. He'll do that, and then once that's done, then we'll call you back up, okay? Mr. Watson, you're set on motion to revoke. Mr. Platten filed a motion for continuance, and the court hasn't ruled on that. He didn't put any kind of vacation letter in with the court, but he's just said he's on vacation and he's not coming today. He tell you that? So he didn't tell you, didn't tell me either until he filed a motion. So what I'm gonna do is I'm gonna go ahead and have you drug tested this morning as well. And I'll just go ahead and tell you right now, if you pass it, then we're gonna reset you because your attorney's not here and I'll deal with him later. And if you fail it, then I'm gonna put you back in jail. Okay,
Judge,
so go ahead and have a seat.
Judge, if I might also, Mr. Platt, put in for the court's information. He put in his motion that he doesn't have discovery on the other case. Mr. Platt has done nothing to get discovery. He's made no requests. He's made no communications that he doesn't have discovery, what he needs. We don't know what he needs. No, he's not here, but just so hopefully you can communicate with your attorney to come get with our office and get discovery that he says he needs, because he's never done anything to get any discovery.
Does he represent?
He represents him on the misdemeanor DWI as well. He has access to online discovery, but he's never made the arrangements to get the videos. He's never requested the videos or made an appointment to come get any of that.
And is that stuff available to him?
Yes, sir.
Okay. So it's not you, Mr. Watson.
It's not you.
It's your attorney that we're trying to get settled. So. I'm gonna try to bring Miss Daly in now. Be on the record. Good morning, Miss Daly. Can you see and hear me okay?
Yes, sir. Good morning.
Good morning. So what's going on with you?
I went to the hospital and they done a COVID test and they called me yesterday and I missed the phone call, so I got to call them back this morning when I get through with my results. But they treated me for COVID and symptoms.
Tell me, how are we doing on what we were ordered to do?
I did do your 2-page report. Actually, it came out to be 5 pages. I paid my court costs. I did my community service, and I thought I paid my probation. I'm sorry. I paid my probation fees. I did my community service. I thought I paid my court costs, but the time I thought that I paid my court costs, it's the same time my wallet got stolen. My new bank card is coming in the mail today, and I will double pay my court costs. But everything else has been on time and up to date and completed.
Okay, so, well, what I'm gonna do is I'm gonna reset you for another hearing in a month. We'll get through with your COVID. And then I do want to see you make all of your payments, and if you can double pay, that's in your best interest. You understand?
Yes, sir. I sure will today. I will pay $100 as soon as my bank card comes in the mail. I will call online, pay the $100, and then I'll email a copy of the receipt to my probation officer.
Okay, that sounds like a plan. They're gonna be expecting it, okay?
Yes, sir. Thank you.
All right, I'm gonna set you for September 28th. September 28th, you need to write that down. September 28th at 9 a.m. Understand?
Yes, sir. I got it.
All right, and then as soon as you get your COVID results, your officer needs to know.
Yes, sir.
All right, you're free to go.
Thank you.
Who are you ready on? Ms. Bueno? All right. And is that a plea today? Okay, can I have the paperwork? Ms. Bueno, if you'll come up to the podium, please. All right, this is cause number CR 2203, State of Texas versus Megan Christine Bueno. State has tendered a motion to dismiss, citing insufficient evidence to support further prosecution. Court will grant the motion and sign the order of dismissal. Ms. Bueno, I show that Mr. Manning was appointed to represent you in this case. I show that you're delinquent $120 on your pretrial release payments.
It doesn't, Ms. Bueno was told by the pretrial release officer, Michelle Waddell, last time she was here, that she'd get that payment today. She has that payment, but she also has an email from Michelle Waddell explaining his wishes for her payments. But
Okay.
she's not doing it.
Okay, so she has that money today?
That's correct.
Okay, so I'm going to order you to go over, once you're released here, just go over to the pretrial release department, make that payment, and then you're free to go. You understand? Okay, all right, you're excused at this time.
Wesley, is here now.
Okay, I'll note that on the docket. Ms. Wesley, if you'll please come forward. This is cause number CR 21198, State versus Amethyst Wesley. We'll let her get up here. Ms. Wesley is set for pretrial today, Mr. Sanders.
Yes, and you're, we don't have any pretrial issues. That's for.
Are you available let's see, we have September 28th. Well, I was really checking with you. I was checking with you. I appreciate that. But I was checking with your lawyer.
Yes, that'd be fine.
Ms. Wesley says she's available, so we got to have her here, so. All right, so court's going to set Ms. Wesley then for docket call on September 28th at 9 a.m. And so, Ms. Wesley, on that date, what I will expect is that you and the state have done all your negotiation through your attorney and some kind of announcement on the 28th as to whether you want to take a plea agreement or you want to request a jury trial or a bench trial, okay? All right, once you sign your notice there and get the yellow copy, you're free to go. Yes, ma'am, September 28th. And Mr. Sanders is going to give you a copy of that right here. Mr. Skinner, if you'll come forward, please, sir. All right, this is cause number CR 2226 and CR 265. State versus Travis Skinner, and we were doing, I believe, a status on the toxicology.
Yes, Your Honor. We actually have two outstanding labs, one at the Garland Laboratory and one at the Laredo Laboratory on this case. The Laredo lab was supposed to release a report on Monday of this week, 23rd. We still have not received that, but they tell me it is forthcoming. The preliminary results that were shared with me on the phone led to us requesting a search warrant that was executed today. Obviously, once we send that off, that is going to take some additional time for testing that specimen. The Garland lab, we have put in basically a rapid processing order request that has been approved, and they have told me that they will do their best to get that returned to us by September 1st. Obviously, we haven't hit that deadline yet, and I haven't received that as well. I did check with pretrial release, and Mr. Skinner is reporting he is complying with all of his conditions. He does have an ankle monitor, and because of that, because the state is requesting additional time for this testing to be completed, the state has no objection to a 60-day reset instead of a 30-day reset.
Okay. Just a moment. Let your attorney speak for you.
And Judge, that's my understanding as far as lab results. Yes, we would ask that it's gonna be reset to have, or be reset out.
Anything further, Mr. Sanders?
He's just, he's got, I think, this month's pre-trial.
Okay. I don't have anything, I don't have just a regular docket in late October, but what we'll do is, since you are in compliance, then the court will set you on November 9th. And that'll give the state additional time, and it'll save you a couple months from having to come up. Okay, so November 9th at 9 a.m. Mr. Schmidt, you still working on your plea papers? So, Mr. Murrow, anyone you want to go first? Murrow. Mr. Murrow. All right, this is cause number CR 18378, State versus Logan Dakota Murrow. Mr. Murrow, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Make sure you speak up as loudly and clearly as you can so my court reporter can take down what you have to say and so that I can hear you as well. All right, Mr. Murrow, you're here on the state's motion to revoke your community supervision, and I find that on January 10th of 2019, you appeared before the court and pled guilty to a state jail felony offense of possession of controlled substance in penalty group 1. The court heard the evidence, found sufficient evidence to convict you, but the court followed a plea agreement and deferred a finding of guilt in your case and placed you on community supervision for 3 years. It's been during your term of community supervision that the state has filed an amended motion to adjudicate and revoke. Have you had an opportunity to review that with your attorney, Mr. Schmidt? You feel like you've had enough time to discuss your case with him, have all your questions answered? Is there anything about the paperwork that you've read and signed today that you do not understand? I see that the recommendation is that Mr. Murrow pleads true to the counts alleged in exchange for the state's recommendation that his guilt be adjudicated, his supervision be revoked, and that he be punished under section 1244A of the Texas Penal Code at 21 days confinement in the county jail, with him receiving 21 days credit for time served, and him being ordered to pay the balance of his financial obligations, which includes $1,000 fine, $1,000 in reimbursement fees, and $353.77 in court costs. Mr. Murrow, is that your understanding of the plea agreement and what you want the court to approve? Mr. Schmidt, do you believe your client to be competent today? And does he waive the formal reading of the state's motion to adjudicate? And he intends to plead true to all counts? Mr. Murrow, then, having reviewed the amended motion to adjudicate and all the counts alleged therein, this time I'm going to ask you, how do you plead to counts 1 through 8? Are those counts true or not true?
True.
And are you telling me that they're true because in fact they are true and you did commit the conduct alleged in those? All right. And Mr. Murrow, has anybody threatened, forced, or pressured you to plead true to any of these counts? All right. The court will follow the plea agreement in this case. Court. Well, let me ask you, Mr. Schmidt, do you have any objection to State's Exhibit A, the defendant's waiver of rights and plea of true? No. All right. State's Exhibit A is admitted. The court does take judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? All right. Court will follow the plea agreement based on the evidence. Court finds that Mr. Murrow has violated the terms and conditions of his community supervision. The court, upon that finding, hereby revokes his community supervision, adjudicates his guilt, assesses his punishment in accordance with the plea agreement under section 1244A at 21 days confinement in the county jail. Court awards him 21 days towards that sentence. Court orders him to pay the balance of his financial obligations, including fine, court costs, and reimbursement fees. Mr. Murrow, are you prepared to pay towards any of your financial obligations today? When are you planning on paying those off? And how much do you think you can pay per month to pay off that obligation? $100? That's going to take you a long time. Well, I just want to have a ballpark idea. I'm gonna have you report back to the court compliance officer, Ms. LaPrade, at the end of the hall on the left. And you're to set up a payment plan with her today. Do you understand what happens if you don't uphold your agreement underneath that payment plan? What is that? When you go to jail and we come back here and we do this whole thing again. You understand? Doesn't do you any good to be sitting in jail. As long as you'll make some diligent efforts to pay it off, then court will work with you. We don't want you in jail any more than you want to be in jail. All right, Mr. Murrow, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with the bailiff, then get a copy of this judgment, and then go down into the hall and speak with Ms. LaPrade. Karen, do me a favor. Take my face off of that. You should be able, I don't see it. I don't know why this one's not there, but if you see this one, just right click it, and just say pin, and it'll do that. Can you do that? I'm tired of putting myself over there. But I don't see the other one. Just my face off of it. And you know what? I don't think we're gonna have a hearing, so if y'all just want to close it, do that too. Mr. Wiley. Mr. Wiley, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Before we jump into all of this, tell me why I should put you back on probation. You put your hand down. Tell me why I should put you back on probation when you were already on probation and you were testing positive for cocaine while you're on pretrial release. Tell me why I should do that. Does cocaine help you get your life back on track? And that's what you tested positive for last time we were in court, right? So it says here that you're agreeing to go to prison for 7 years if you violate your conditions of community supervision. You've already done that. You've already violated your conditions of community supervision, right? And that's what you're going to tell me today if I approve this plea agreement, right? So if I approve this and I put you back on probation and you violate, then what happens next? For 7 years. So Mr. Wiley is going to do 60 days in jail as a condition of community supervision. He's going to get 64 and he's going to get credit for 4. He's going to serve 60.
That's correct, Your Honor. And additionally, we are going to be placing him on intensive supervision to make sure that Mr. Whiteley has been on probation for a good stretch with no positive drug tests, minus his court setting last month. So with the ISP, with the 60 days in jail, we feel that that sufficiently covers the sequel violation. However, Mr. Whiteley doesn't understand any violations moving forward at all. This is the second case. We will not be getting.
Mr. Wiley, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with him representing you? And do you feel like you've had enough time to go over all this paperwork with him? And do you have any questions about any of it? Mr. Schmidt, do you believe Mr. Wiley to be competent today? And does he waive the formal reading of the state's motion? Is he gonna plead true to all counts? All right, Mr. Wiley. I ask you at this time, how do you plead to counts 1, 2, 3, 4, 5, and 6 in the state's motion? Are those counts true or not true? Let's take a few minutes. Let's take a few minutes. Let's let him get, go ahead and have a seat, Mr. Wiley. It's okay. Hey, why don't you have a seat? It's okay. I want you to take it. I know. I want you to take a few minutes. Just get a deep breath. We're in no rush. We're in no rush. I understand the gravity of the moment. Just take it easy for a second. Need a drink of water or anything? That help? No, I understand, but you want a drink of water, get your heart rate under control? Mr. Schmidt, if you'll approach. Come on, we're just, what's that? That's all right. That's all right. I understand. All right. All right, this is cause number CR 18-113, State versus Landon J. Watson. Record will reflect that Mr. Eric Platten is not present in court today. Mr. Platten did file a motion for continuance, asking for this hearing to be continued to another date. However, the court did not rule on that motion for continuance, so I neither granted it nor denied it. And so it was my intention for him to be here today, but I knew based on reading the motion that he was not going to be here today because he says he's on vacation. Typically, attorneys will file a letter of vacation and we won't set things during that time. He didn't do so in this case. And at our last setting, I believe that the state filed a motion for continuance and I had granted that. So Mr. Platten's not here today. We're not going to go forward on your case. Probation department has indicated to me that you tested clean. So I'm glad to hear that. So what I'm going to do is I'm going to reset your case, Mr. Watson, and we're going to reset you until September 28th. I'm sorry, that's not right. Let me look. September 30th. Okay, so that'll be our next hearing date. The deputy here is going to have you sign this notice of setting. We're going to give you that. So what Mr. Woodwike indicated earlier is what Mr. is in relationship to what Mr. Platten had said in his motion, which he's saying that he doesn't have your misdemeanor, your new offense, DWI. He doesn't have that evidence, so he can't go forward in this case. But what the state's indicated to the court, what we're going to discuss today is why doesn't he have that? The state's indicated he's not requested it. He's not going to get that. So this doesn't reflect negatively on you, but I think you should have that conversation with your attorney about, is he trying to get your case resolved or not? Okay. So you'll sign right here. We'll give you the yellow copy and then you'll be good to go. Sir? So just make sure you understand you're still on probation. You still got to report, pay, can't drink, can't do anything. That's a violation of your probation. You understand? Okay. All right, you're free to go. All right, Mr. Schmidt. Will you approach Mr. Schmidt? State. It's okay. All right, we're back on the record, CR 1934. see, where did we leave off? All right, and I believe that the court had admitted State's Exhibit A. So at this time, I think we should be at the point. State, do you have anything else to offer? Defense? All right, Mr. Wiley, so the court's going to follow your plea agreement. I'm going to give you another opportunity on community supervision. Court will find that you have violated the terms and conditions of your community supervision. Court will adjudicate your guilt. That means today you're going to be convicted of the third-degree felony offense of injury to a child, elderly, or disabled individual with bodily injury. Court's going to assess your sentence at 7 years confinement in the Texas Department of Criminal Justice. Court's going to find that it's in the best interest of the defendant and the community for that sentence to be suspended and for you to be placed on community supervision for 2 years. Court's going to order you to pay the balance of your fines and reimbursement fees and court costs. Court's going to, as a condition of your community supervision, order you to be placed on intensive supervision. Court's also going to order you to serve 64 days in the Van Zandt County Jail as a condition of your probation. The court's going to award you for 4 days of time already served as indicated in the judgment, with you serving out the remaining 60 days, and the court is going to order you into custody on this date. All right, Mr. Wiley, if you'll come forward, the bailiff's going to have you fingerprinted on the judgment, and then you're going to be taken into custody. Mr. Schmidt, do you ever hear anything back from Mr. Dittman, or do you think he's a court can go ahead and reach the obvious conclusion? All right, who are we ready on first, Mr. Sanders?
Mr. Vasquez.
All right, Mr. Vasquez, if you'll step up, please. This is cause number CR 1878. All right, Mr. Vasquez, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you put your hand down. You are Shelton Vasquez, is that right? And Mr. Vasquez, you appeared before the court back in October of 2018, and you pled guilty to the offense of prohibited substance or item in a correctional facility. Court heard the evidence in that case, found that there was sufficient evidence to convict you, but the court followed a plea agreement and deferred a finding of guilt and placed you on community supervision for 6 years. Court also assessed a $2,000 fine. During that term of your community supervision, the state filed an amended motion to adjudicate and revoke. Have you had an opportunity to review that with your attorney, Mr. Jeff Sanders? You feel like you've had enough time to discuss the case with him and have all your questions answered? Mr. Sanders, do you believe Mr. Vasquez to be competent today? And does he waive the formal reading of the state's motion?
Yes.
And does he intend to plead true to all counts in exchange for the recommendation that his guilt be adjudicated, his supervision be revoked, and he be sentenced to 4 years in TDCJ?
Yes, sure. That's correct.
All right, so Mr. Vasquez, I see here that that plea agreement also includes you to not only serve a 4-year sentence, but also pay your balance of your financial obligations, which includes restitution and court costs. And you would receive 612 days credit towards that sentence for time served in this case. Is that your understanding of the plea agreement today? All right, so Mr. Vasquez, at this time, I'm going to ask you, how do you plead to counts 1, 2, 3, 4, 5, 6, 7, 8, 9, and 10 as contained in the state's motion? Are those counts true or not true? And are you telling me that those are true because the conduct alleged in each one of those counts is true? And has anyone threatened, forced, or pressured you to plead true today? All right, the court will accept the defendant's plea of true. Mr. Sanders, any objection to State's Exhibit A?
No.
State's Exhibit A is admitted into evidence, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, move the rest of the case.
From the defense? All right, then based on the evidence, court's going to find that Mr. Vasquez has violated the terms and conditions of his community supervision. Court will follow the plea agreement in this case. Court hereby adjudicates Mr. Vasquez's guilt for a 3rd-degree felony offense of prohibited substance or item in a correctional facility. Court will revoke his community supervision, assess his punishment at 4 years confinement in the Texas Department of Criminal Justice, and order him to pay the balance of his financial obligations. And the court awards him 612 days time credit towards this sentence for time served in this case. All right, Mr. Vasquez, I'm gonna have you step forward to be fingerprinted by the deputy, and then you're gonna be taken into custody. Who are you ready on now, Mr. Sanders?
Hey,
Ms. Gandy? All right, Ms. Gandy, if you'll raise your right hand, please, ma'am. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Make sure you speak up loudly and clearly for me. Ms. Gandy, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? Okay. In this case, your attorney is Mr. Jeff Sanders. Are you pleased with his representation of you? You feel like you've had enough time to meet with him, discuss with him your case, and have all your questions answered? Is there anything about the paperwork that you've read and signed that you do not understand? Mr. Sanders, do you believe Ms. Gandy to be competent today? And you've explained to her her legal rights and also the advantages and disadvantages of a deferred adjudication plea?
yes, sir.
All right, I see here that the proposed plea agreement is that she pleads guilty to a state jail felony offense of possession of controlled substance in penalty group 1 less than 1 gram. And the state's recommendation is that finding of guilt be deferred with a recommendation for 3 years community supervision, a $3,500 fine, court cost of $290, reimbursement fees of $535, and restitution of $180. Ms. Gandy, is that the plea agreement that you want the court to approve today? And you understand that the range of punishment for this charge, a state jail felony, is confinement of not less than 6 months or more than 2 years in a state jail division of TDC. What that means for you is if I place you on community supervision today pursuant to this plea agreement, and during that term, you violate any of the conditions of your community supervision, the state could file a motion to adjudicate your guilt, bring you back before the court. And if they prove to me that you violated, then the issue does not become whether you possess controlled substance, because you're going to have waived your right to a trial on that matter. The issue is going to become, did you violate? And if I find that you did, then I can assess your punishment anywhere between 6 months and 2 years in the state jail division of TDC. Do you understand that? Understanding that range of punishment in the plea agreement, do you still want to go forward? All right, then, Ms. Gandy, how do you plead to that offense? Are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty today? The court will accept the defendant's plea of guilt. Mr. Sanders, any objection to states 1?
No.
All right, states 1 is admitted into evidence. The court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? All right, based on my review of the evidence, I find that there's sufficient evidence to convict Ms. Gandy of this offense. The court, however, will follow the plea agreement in this case. The court defers the finding of guilt, places Ms. Gandy on 3 years community supervision. Court assesses a $3,500 fine, $290 court costs, $180 restitution, and orders Ms. Gandy to reimburse Van Zandt County in the amount of $535. All right, Ms. Gandy. I'm going to remand you to the custody of the Community Supervisions Department. So go ahead and step up. I'm going to have you fingerprinted. After that time, go with the officers over here through this door. May have missed some signatures in there, I don't know. Mr. Whitaker? Right answer. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you may put your hand down. Your name is Deshaun Malik Whitaker, is that right? And Mr. Whitaker, are you a United States citizen? And do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Sanders. Are you pleased with his representation? Feel like you've had enough time to discuss your case with him and have all your questions answered? Is there anything about the plea paperwork that you've read and signed today that you do not understand? You understand everything? If you have any questions, this would be the time to find out. You understand everything? All right, Mr. Sanders, do you believe Mr. Whitaker to be competent today? Have you explained to him his legal and constitutional rights and also the advantages and disadvantages of a deferred adjudication plea?
Yes.
All right, Mr. Whitaker, I see that the plea agreement is that you're going to plead guilty to a state jail felony offense of possession of controlled substance and penalty group 2, less than 1 gram. State's recommending that a finding of guilt be deferred, that you be placed on community supervision for 2 years, that you pay a $2,500 fine, $180 restitution, and that the state's going to dismiss a possession of marijuana case. In addition, you would have $35 reimbursement fee. Mr. Sanders, are you retained in this case?
Yes.
Okay. So, Mr. Whitaker, is that your understanding of the plea agreement? And I want you to understand that the range of punishment for this offense is confinement, not less than 6 months or more than 2 years. Confinement in the state jail division of TDC. Just like the young lady that appeared before you in court, I told her, I'm going to tell you the same thing. If I approve this, place you on community supervision, if you violate your community supervision and it's proven to me, then I can assess your punishment for this offense anywhere from the minimum 6 months to the maximum 2 years. You understand that? Sorry. Sign it, talk, do all that stuff. Yes. Yes, sir. Yes, sir. That's fine.
they had given us two different offers. The deferred offer that we were starting to proceed on, or the alternative was to plead guilty to the charge for time served under 1244A, which would mean a conviction and then there would be fine. I believe it says fine either way. And so I know we've discussed that. I know Mr. Whitaker's kind of gone back and forth a little bit about that. It's basically it comes down to have a felony conviction on it. And I think from what he's indicated, he would rather now go ahead and take the other option of pleading guilty to the time served under 1244A and pay the fine. So
Would that be paying the fine at the time of plea?
I think you might have set a plan for that. So I don't know if, I know that would involve redoing some of the paperwork. I don't know if that's something that.
What if we ask Ms. Abney to do that and we come back this afternoon and complete the plea this afternoon?
It's just wait for we will do our best. There are a number of pleas this afternoon, which is still working on. So ask for the staff.
It looks like all we need is a judgment and the plea admonishments. And everything else is done. So Mr. Whitaker, what I'm gonna do is I'm just gonna order you to come back to the courtroom at 1:30 this afternoon. And we're gonna change up the paperwork and you can enter into that plea agreement. Okay? So be back here at 1:30. You're free to go. I'm just gonna hold on to these. Unless you want to take these back to Stephanie so she can see her. Yeah, I think just a judgment and admonishment would be the only thing. Everything else should be the same. No, I don't believe so. I'm gonna have Danny, Mike Dittman saying Paul 3 times, and so. Do that at this time.
Absolutely. What was the name?
Danny, Mike Dittman,
Dittman?
Dittman, Dittman. Mr. Dittman does not like to come to court. Any response from Mr. Dittman?
No response, Your Honor.
All right, record will reflect. This is cause number CR 18-7, State versus Danny Mike Dittman. Mr. Dittman was set to appear today on a motion to adjudicate a possible plea. His name was called at 9 a.m. He was not present. His name has been recalled at present time 11:40 a.m. Mr. Dittman is still not present. Court hereby orders a judgment nisi and issuance of an alias capias. All right, that will conclude this morning's docket. Will be adjourned until 1:30.